Let's go to premium pay. Under Article 93 of the Labor Code, when the employee is permitted to work on his or her scheduled rest day or special holiday, the worker is entitled to 30% of his or her regular wage. The only exception when there is a higher pay or higher rate if it is provided in the collective bargaining agreement or other employment contract where higher premium pay is agreed. So when you talk of premium pay, it is payment for the 8 hours of work rendered by the employee. When you distinguish that from overtime pay, it is payment for the excess of the 8-hour work based on an hourly rate, and you multiply that with 25%. So the distinction should include also the rate, where when you talk of premium pay, the rate would be 30%, and then when you talk of overtime pay, it's 25%. And the basis is different because the 30% will be based on the 8 hours of work, while the overtime pay is based on the hourly rate of the excess of 8 hours, which is on a per hour basis. Let's go to holiday pay. Under Article 94 of the Labor Code, it provides that every worker shall be paid his regular daily wage during regular holidays, subject of course to exception. Second paragraph, the employer may require the employee to work on any holiday, but such employee shall be entitled to 200% or twice of his regular rate. The exception to this law or Article 94 is found in Rule 4, Section 1 of the Implementing Rules of the Labor Code. So these implementing rules provide enumeration. Those employees of government or any of the political subdivision, including government-owned and controlled corporation. Those of retail and service establishments regularly employing less than 10 workers, which means 9 workers, regularly employing 9 workers. Domestic helpers and persons in the personal service of another are also exempted from holiday pay. Managerial employees are also exempted. And lastly, you have field personnel and other employees whose time and performance is unsupervised by the employer, including those who are engaged on task or contract basis, purely commission basis, or those who are paid in a fixed amount for performing work irrespective of time consumed in the performance thereof. So regarding monthly paid employee, practically there is no distinction between monthly paid employee and daily paid employee, because the principle of fair day's wage for a fair day's work applies. So if a monthly paid employee performs work on a regular holiday, and provided the day prior to that holiday the employee is on leave with pay or it is his or her rest day, then the employee is entitled to 200%. That applies also to daily wage employee. So in the succeeding case of Odango versus NLRC, the Supreme Court struck down Section 2 of that implementing rules, which provides that monthly paid employees are presumed to be paid for all days in the month, whether worked or not. So that is wrong, because this holiday pay rule applies both to regularly or daily wage employee and those who are monthly paid employees. So I mentioned earlier that for an employee to avail of the regular pay, the employee should work on the day prior to the regular holiday, or if the employee is on leave with pay, or the employee is or it's the employee's rest day. Otherwise, the employee should work prior to that holiday in order to avail of holiday pay of 100%. So in which case, the employee under Section 6, Rule 4 of the implementing rules should perform work on the day prior to the regular holiday. If the employee wants to be paid on that regular holiday without working on that day. So take note of Odango vs. NLRC, June 10, 2004, where the Supreme Court struck down Section 2, Rule 4 of the Omnibus Rules of Implementing Rules, Omnibus Implementing Rules of the Labor Code. So settled now is the rule that a monthly paid employee is entitled to holiday pay if the employee will work prior to that day, or spending his rest day, or on leave with pay. So the principle of fair day's wage for fair day's work applies also to monthly paid employee in relation to availment of holiday pay. The computation as to how much the holiday pay should the employee receive if the employee performs work on regular holiday, then he's entitled to 100%. If the regular holiday falls on rest day, there will be additional 30%, and so on and so forth. So the questions will I think the questions here will be all about the entitlement of monthly paid employees and daily paid employees. So they're just the same. Subject, always remember the availment or the entitlement of these two groups of employees. You have to take note of Section 6, Rule 4 of the implementing rules and regulations of the Labor Code. Let's go to the next topic. By the way, regarding regular holidays in the Philippines, we have now 12 regular holidays. In addition to the existing 10, the Muslim holidays were added, so that's now 12 regular holidays. Regarding the enjoyment of holidays for Muslim and Christians, if it is a Christian holiday, then the Muslim workers are entitled to the same privilege. Because according to Supreme Court, the applicability of the law is not dependent on the workers' religion. That's the case of San Miguel Corporation versus Honorable Court of Appeals. Also, you should not be confused of special holidays and special days. They are just the same. Let's go to service incentive leave. Under Article 95 of the Labor Code, it is provided that every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. Now, let's look at the coverage. There is what we call list of exceptions under Section 1, Rule 7 of the Implementing Rules. 1. Those of the government and any of its political subdivisions, including government-owned controlled corporations, are exempted from the coverage of service incentive law. These domestic helpers are already qualified because under Section 29 of the Kasambahay Law, the domestic worker is now entitled to service incentive leave, provided the domestic worker has rendered at least 1 year of service. The only difference is that this service incentive leave enjoyed by Kasambahay or domestic worker is not cumulative and is not convertible to cash under Section 29 of RA 10361. So, domestic helpers are not anymore exempted, but you have to specify, no, that this service incentive leave is different when it comes to aspect of being cumulative and convertible to cash. Then let's go to another group of exempted employees. You also have the managerial employees. Then you have the field personnel, or other employees whose performance is unsupervised by the employer, including those who are engaged on task or contract basis, purely commission basis, or those who are paid on fixed amount for performing work irrespective of time consumed in the performance thereof. Another group for those employees who are enjoying the benefit provided herein. Another one, those who are enjoying vacation leave with pay for at least 5 days, and those employed in establishment regularly employing less than 10 employees. So those are the enumerations of exceptions, no, to the coverage of service incentive leave. Let's go to night shift pay. Under Article 86 of the Labor Code, every employee shall be entitled to a night shift differential of not less than 10% of his regular wage for each hour of work performed between 10 o'clock in the evening and 6 o'clock in the morning. So when you talk of night shift work, there are two kinds of night shift work, no? When it is on a regular work, or it is done as, or it happens during overtime work. So you have to distinguish if night shift differential is given to an employee who performed during ordinary day or during a special day, the computation will be different. Because when you talk of ordinary day and it is an overtime work, you have to add 10% of the 125% per hourly rate basis. If it is a rest day or a special day of the employee, then you get the 10% of the 130% of the hourly rate of the employee, because it is a rest day based on that hourly rate. So you distinguish. Now, if there's a question here, it would be the two types of night shift differential. One performed on the regular day, which only 10%. The other one, if it is performed as an overtime, on an overtime work, that's why you add 25%. If it is an ordinary day and a special day, 10% of the 130%. Okay, let's go to 13-month pay. This is another mandatory benefit as provided under the Labor Code. It is provided in Section 1 of PD 851. This has been amended by Memorandum Order number 28 of former President Corazon Aquino, wherein she removed the limit, because under PD 851 this 13-month pay excludes from entitlement those employees who are receiving basic salary of more than 1,000. Now, under Memorandum Order number 28 by the Cory Aquino administration, it was now removed, so everyone is entitled. However, you have to take note again of the exceptions to the coverage of the 13-month pay law. You have government and any of its political subdivision. You have employees already paying their employees a 13-month pay or more in a calendar year, or its equivalent at the time of the issuance of Memorandum Order number 28. Then employers of household, helpers, and persons in the personal service of another in relation to such workers, and workers of those who are paid purely commission, boundary, or task basis, and those who are paid a fixed amount performing specific work irrespective of time consumed in the performance thereof. However, take note of the exception because where the workers are paid on piece rate basis, in which case the employer shall grant the required 13-month pay to each employee. So take note of that exception. Now, how do you compute the 13-month pay? So you have to get the total number of work days performed by the employee in a year, and you divide it with 12. Then the result will be the 13-month pay. So is it possible that the 13-month pay will be equivalent to 1 month's salary? If the employee did not commit any absences, then most likely the 13-month pay will be the same or equal to the 1 month salary of the said employee. For purposes of tax treatment of 13-month pay, although it may not be relevant, but there is Republic Act 10658. Under this law, this Internal Revenue Code of the Philippines has been amended because this law provided exclusion from gross income and shall be exempt from taxation under this section 32 of the Internal Revenue Code has been amended. It is provided in section 7 paragraph E that the gross benefits received by officials and employees of public and private entities, this 13-month pay and other benefits are exempted, provided however that the total exclusion under this paragraph shall not exceed 82,000. Then, as regards drivers and conductors of public utility buses or transport industry, they are entitled to 13-month pay and even other incentives under DO 118-12. So far, those are the remaining topics as regards hours of work. The next topic will continue in a separate clip: job contracting and labor only contracting.